I'm Neil Taylor, Director of the Corporate Law Center at the University of Cincinnati College of Law. Welcome to Corporate Law Lab. Our guest today is Andrew Battisson of Linklaters. Andrew heads Linklaters' international arbitration practice in Asia-Pac and the Middle East, based in Singapore. I really enjoyed catching up with Andrew and exploring his journey from growing up in Australia to becoming a leading expert in the important and growing field of international arbitration. So let's start off with kind of who you are, what you do, how you do it, why you do it. That should be about an hour. And then we can go on to my other questions. But let's just start with, how did you decide to become a lawyer? Are there lawyers in your family, or is that something that you decided to pursue for whatever reason?
So perhaps somewhat boringly, that there are lawyers in my family. My father was a government labour lawyer on the policy side, and my mother was actually a legal secretary for one of Australia's leading criminal barristers in her time. And so there were some very interesting stories around the family dinner table, sometimes with both labour and crime coming together in one way or another, but around various protests and things. So that was part of it. And then I was always interested in the ways of societies kind of worked and interacted with each other. So that was the other part of it. It just kind of led me naturally towards law school.
So you went to law school in Australia, where you're from, right?
Yeah, exactly. So I was also lucky that I happened to live about 10 minutes drive from one of Australia's leading law schools at the Australian National University. So that probably also was some part of an influence. But yeah, so I kind of grew up with that, and I went literally, unlike say in the US, I literally just lived at home throughout you could do law school as an undergraduate in Australia, and I did. It took 5 years, but I spent 5 years just kind of, tottering back and forth between my parents' house and the School of Law.
And did you then practice in Australia, or did you immediately take off for London?
Not quite. So I did do, my 2-year sort of training contract, as they might be called, so my apprenticeship for Freehills, as it now Herbert Smith Freehills, and in Sydney. So I had to move from Canberra, where the Australian National University was, up to Sydney, and I did those 2 years, and then once I'd finished that, I was lucky enough to win a couple of scholarships to go to Oxford. So that's what took me out of Australia for my master's, actually.
So you did a Master's of Law at Oxford?
Yeah, I did. So that was a 1-year taught course, and then having shifted my whole life, over to the other side of the world, there was two reasons. So all of these things are sort of personal and professional. Professionally, it was obviously very interesting to be able to go and work in London, and then personally, my sort of now wife, but then girlfriend, had moved to London, so I was highly motivated to find a job in London.
And you landed at Allen and Overy, which, if you're going to land someplace in London, isn't a bad place to start.
Yeah, no, it was.
Was that your first job?
It was, yeah, first job in London. So, and actually I spent 13 years at Allen and Overy in London and Singapore. So it was an excellent grounding for what I now do.
Did you start immediately in the international commercial arbitration process, or did you find your way there?
I kind of found my way there. So I started in the litigation team, and actually, this is going back a while. I'll reveal my age. This is sort of 2005, 2006. And there weren't a lot of non-English people in the litigation team, sort of as in non-UK based lawyers. And so the arbitration team kind of was a bastion of Antipodeans. There was Australians and New Zealanders. So Stephen Yagush, who's now head of Quinn Emanuel's practice, was there. And that kind of dragged me over, because otherwise I was doing a lot of sort of, ANO has a strong banking practice. I was doing a lot of banking litigation, and I just didn't find that was quite as interesting as the commercial arbitration side.
So talk about the commercial arbitration and I guess international commercial arbitration in particular. How does it different from normal litigation?
So I guess the key difference, for international commercial arbitration is that it's essentially a contractual agreement between parties to privately resolve their disputes, their commercial disputes, and it has a long and venerable history that goes back hundreds of years to sort of maritime arbitration, trading nations in Europe, etc. But in its more modern form, it's sort of underpinned by the New York Convention from 1956, which 170 odd countries are signatories to provide for the enforceability of an arbitral award around the world. So, but critically, it's used particularly for cross-border trade, where you want a sort of neutral panel, so you may not be happy with one party putting itself before the courts of another party's home court. So it's neutral, it's confidential, but it ultimately rests on contract.
And then a subspecies of that is investment arbitration, right? Where, say, a company goes to invest in a particular country and doesn't necessarily, I guess, trust is the right word, that they would be treated most fairly in the courts of that country, and as a condition of making the investment, get the country to agree that there will be an arbitration in any disputes. Did I get that sort of right?
Yeah, definitely. Sort of right. I mean, you and I have been through it actually, so we have some sort of history in this. I mean, so yes, it's correct. So the idea is to depoliticize investments and investment disputes, so really how it works is, famously it's been described as arbitration without privity, but you have a treaty between a home state and a host state. And that treaty permits an investor from the home state to invest in the host state, and the treaty accords certain protections for those investments: fair and equitable treatment, those freedom from expropriation without compensation, etc. And in the event that there is a problem, the investor has a right to directly commence arbitration against the host state, and doesn't need to rely on the home state to bring a sort of diplomatic protection action against that state. So, and then that's supported obviously by the sort of investment treaty architecture.
So the underlying commercial deal doesn't necessarily have to be between the investor and the state. It's just like, if I'm going to start a mine, I guess would be one place where it comes up. I'm not necessarily making a deal with the country to start that mine, but I'm making a deal with the country that if any disputes around that business enterprise will be resolved outside of the courts of that country and in a particular forum.
Yes. So in fact, you could be doing both. So you could, of course, enter into an investment contract that sets all of that up, or otherwise you could avail yourself of the existing treaty regime. And you're right, the important point I didn't mention earlier is, if there is a dispute, then it doesn't go to the courts of that host state, it goes off to a neutral tribunal. And so in that way, you protect yourself or insulate yourself from perhaps courts you're concerned about.
Yeah, I mean, the particular case that you and I dealt with was, and it's in the public, so most of it we can talk about, was the government of Senegal. And in that case, it actually was a direct deal between the company that I was GC of at the time and the country of Senegal for a mobile network operator license that became a subject of some dispute. And in that case, we were in front of ICSID. Could you talk about what ICSID is?
Yeah,
because it's one of those things. I think by the time when we started that, I'd been practicing, I don't know, 15 years or so, and had never once heard the acronym ICSID, and got to learn quite a lot about it from you guys.
Yes. Well, that's true. So, and I mean, really, that was in the sort of early wave, and it's really sort of, it was gathering pace then, and of course it's continued since. So ICSID is short for or an acronym for the International Centre for the Settlement of Investment Disputes, and that is a body set up under the auspices of the World Bank, and it was brought into being by something called the 1965 Washington Convention, which established the sort of basic principles for the ICSID system, and to basically facilitate investment disputes. And so it provides the secretariat and the sort of administration for those investment disputes that come under, say, a bilateral investment treaty or a multilateral investment treaty. So in the US, historically, you might have had NAFTA claims that would sometimes go to ICSID, or you would have, in the case we did, I think there was a treaty between the Netherlands and Senegal, and it was actually your then company's Dutch sort of corporate entity that had invested into Senegal. And so it fell under the purview of that treaty, which gave it the various rights that we subsequently looked at very closely.
And I guess a practice pointer is when you are setting up such a regime, you need to be very careful, and certainly more careful than my predecessors were, about how you write the grant of jurisdiction to ICSID.
Yes,
you remember we spent a year arguing over whether it meant, whether that particular French word, I think it was pouvant, meant should or shall.
Yeah, that's right. And I think it's fair. I mean, these treaties obviously the first generation of them date back to the sort of 60s and 70s, when it was really seen as something to encourage investment from a capital exporting country into a capital importing country. So often from developed Western countries into developing countries. That's obviously changed now, but at the time, some of those treaties, I mean, those treaties were 3 pages long. And now, of course, if you look at the standard sort of US model treaty, it's much longer than that and far more nuanced and carefully drafted. So you're right that a practice point is care is needed, in the same way as you would expect to actually see if such treaties are available. In the way that companies today look at tax structuring when they're making an investment, we would also encourage them to look at ensuring they have treaty protection.
These cases, you don't bring an ICSID case over a minor kerfuffle, right? It's got to be something big, right?
Yeah, definitely. I mean, obviously it has political ramifications potentially, and it has and it's it's also expensive, so it's a big undertaking. So you would only do it for something. If you look at the ICSID website, actually has useful statistics, and it shows that half of all disputes basically turn around natural resources, mining, those type of issues. My personal theory is that's because those investments involve very high upfront costs and a long repayment period, a lot of government interaction in terms of licensing and regulations and things. And so you've got a lot at stake early on, and you tend to make your money as an investor towards the end. And so there can be changes of government, changes of political regime, etc. So it's those kind of things that give rise to these disputes. I mean, they are, as you say, not your everyday variety, and they're not meant to be for just basic contractual disputes.
Yeah, I mean, in the case that we were involved in, I believe we were 10 years into a 20 or 25-year license when the trouble arose.
Yeah.
And building a mobile network in to cover an entire country is obviously something of an undertaking, and we hadn't made our money back for sure by that point.
Yes, yeah, exactly. That's right. You'd build all the infrastructure, but you hadn't yet had the return.
So that means that you're generally dealing with corporate counsel who are under quite a bit of stress in this case, right? And you never have a run-of-the-mill case where you're dealing with corporate counsel. Is that accurate?
I think that's accurate. I mean, I don't know if you recall, Neil, but you called me, I think, at 5 p.m. one day when you'd been served with the proceedings in the local courts in Senegal, and said, commence the ICSID case by midnight. So, probably the fastest commencement of an ICSID case ever. You're right. I mean, these are typically they are atypical disputes, and therefore then it's not run of the mill.
I thought we won the race to the courthouse. Did we? We were a few hours behind, huh?
We were 1 minute spare. Is my recollection.
So you're not. There's not like a playbook. You're not generally dealing with a corporate counsel who has experience with investment disputes. Is that fair?
Yes, I think that's fair. I mean, outside of a couple of very large corporations who, perhaps in the sort of big miners maybe, but otherwise, that is fair.
Now, how does that relationship work best? I mean, and I can talk a little bit. I'd love to hear more about people that aren't me. I can certainly talk a bit more about my experience and how I must have been frustrating the heck out of you guys at times. But um, how does that relationship work well? And what are the pressure points that make it difficult for you and for corporate counsel?
So I think communication is going to be the absolute fundamental point for a relationship working well, um, uh, and in particular, we sometimes external and corporate counsel might have slightly different drivers. So corporate counsel in particular have to deal with the entire structure that sits behind them within the corporation. There'll be political concerns, commercial concerns, which don't always directly relate to how do we what is the evidence for our position or where is. And so as external counsel, part of my job is to help corporate counsel succinctly and relevantly deal with the issues they've got, and then separate I need to be able to do that. Then I need access to information or an acknowledgement of where there are gaps and sort of constructive thinking about how we might go and fill those. Because no matter what the dispute is, ultimately it all turns on some application of the facts to the relevant law. And so there might be different ways of doing that, and finding the facts might be buried in millions of emails or whatever. There's technology to help solve that problem. But at the end of the day, sort of collaboration and communication is really fundamental to making the relationship between corporate counsel and external counsel work well.
Does it ever drive you nuts that corporate counsel has to pursue kind of their own agenda? I mean, in our case, it was a very political matter. Um, Normally, when I was outside counsel, I would love it if my um, in-house counsel wasn't out talking in the press. But in our case, I certainly was. I was talking in the press. I was causing as much trouble as I could wherever I could to try and, bring attention to the matter and put pressure on, the other side to resolve it in a way short of, going through the end of an ICSID arbitration.
Yes.
There's a question in there somewhere.
Yeah, no, I have it. So I think the sort of critical point of that is to have an agreed strategy. So on these very large type of disputes, you may well have a PR strategy or a strategy that exists outside of the courtroom to either from a lobbying perspective or to deal with policy issues that are relevant. And provide, if you've got a strategy, then obviously ideally you'd be working on it together. And that's probably the best way of doing it. I must be, as I've got older and more experienced, I get less frustrated if people stray off script and unexpected things happen. That sort of just adds interest to the day. And these are corporate disputes that it's not often the case that they're matters of life and death. So you can afford the occasional detour along the way.
Well, I was driving you crazy.
Yeah, I would absolutely not say that.
You mentioned technology and how that plays into investigating, resolving, presenting these disputes. How's technology changed over the 20 some years? You're up to 20 years now, right?
I am up to 21, I think. Yeah.
Yeah.
Yeah. So I think right now with the AI sort of tools that are just beginning to filter through in the mainstream, that is probably the most exciting technological change. I think previously, the last 20 odd years, I mean, the fact that we're having this conversation over Zoom, I mean, one of the biggest changes to my life is I no longer have to travel everywhere to see witnesses in different parts of the world, because the vast majority of what I can do virtually. And hearings can be done virtually now very effectively in a way that just wasn't foreseeable or wasn't possible 10 years ago, and certainly not for any sort of acceptable cost. But actually, mostly technology in the last 20 years has just been keeping up with the increase of data. email and WhatsApp, all of the different kinds of data and sources that you need material for disclosure, actually it's just overwhelming. So when I first started, people were still putting together paper chronologies, right? And within a year or two, that had gone, and now it had all been replaced by various tools. And I think those tools have just about kept pace with the increase of data. But now, for the first time with some of the AI tools, you can really start to interrogate that data in a way that previously it was just about organizing it in a sensible fashion. Now you can go deeper, and that's where technology is really changing.
Do you think that AI will make it more efficient? Because I know, as you know, in my days, I spent times in basements going through old boxes from 30
Yeah.
years ago. Now I suppose all of that stuff would be at least digitized and maybe interrogated by AI, as opposed to sticking me in a basement
Yeah.
for a couple of months. Um, do you think that actually leads to efficiency, or is it just another way that we keep loading on cost? And
Well, I
and,
think
and I know that sounds very corporate counsel talking grief to I almost used another word, but
yeah.
to outside counsel about why you're spending all my money on this stuff.
Yeah, and so partly to avoid you having to spend money on us hanging out in the basement for a couple of months, which is pretty inefficient. So I think, look, done right, of course, it does have the ability to generate efficiencies. To give you just a real world example, it's in the public domain. I've been doing a number of disputes enforcing exit awards against the Kingdom of Spain, and I've just been through a big trial. A lot of expert evidence from academic professors was being filed over various elements of sovereign immunity. And these were massive reports, and it was all happening incredibly quickly. And one of them I was able just to put into my firm's in-house sort of chat GPT version and say, can I please have, give me the summary, right? I need I've got this report. I had 1 hour to sort of, before I had to go into a meeting with my in-house client to explain what was in the report. Obviously, it was 150 pages long, so I couldn't read it, but I did at least need to have a sense of what it said. And so that allowed me in that half an hour to just get a quick summary of what it was, sense check a couple of points, and then away we go. And I think that those kind of the ability to deal with chunky, bulky documents and cut it down to size is a genuine efficiency. And then the ability to sort of start getting rid of, if we do a big data capture, we get 5 million emails from day one to a date X to date Y. Within that, there'll be a small number of really relevant ones and probably a whole lot of false positives. If you can train the system to just get rid of the false positives, and obviously you have to sense check all of these things and make sure that there's no, it's being done, there's no hallucinations, it's being done properly. That's a big saving of time and cost.
Yeah, because back in the day when you're reviewing documents, so many times you're looking at the same document over and over and over.
Yeah, exactly. And like email chains in particular, right? You might end up with 100 copies of the same email chain, perhaps each iteration or multiple, or it diverges often, and all of that is not. There's not a lot of value in in paying a lot of money for that to be chilled out if you can distilled out if you can find a way of just cutting to the chase.
So with that, how has the working relationship with corporate counsel changed over the years, if it has?
So I think it has, in the sense that it's become more collaborative, and I think the best external counsel and the best corporate counsel do work on their relationships. And it's funny that despite no matter what that you talk about technology, at the end of the day, there's still a personal relationship that exists between a group of people, and so. And just the willingness to be open. I mean, in any large litigation takes several years potentially. In that period of time, there were going to be ups and downs, and things will go for and against you. And you have to have some form of relationship to be able to deal with the difficult points, as well as to be able to celebrate the wins. And so, in that sense, I think that people are even more recognizing that than they were before. And I know when I'm employing, like working with local counsel, the thing that drives me nuts is if people don't want to sit down and engage with me and my client. And that in that collaborative way. And so as long as, and I think that is what's happened. I mean, by and large, the vast majority of good corporate counsel I now deal with are interested in having a broader relationship and engaging in the sort of strategy of things. By and large, I mean, obviously sometimes people are overwhelmed and too busy, and you're being employed because actually it's just a way of sort of expanding the team. Just go away, solve the problem, bring it back. That's fine. Everyone understands.
But in the bet the company cases, or bet the significant part of the company cases, I don't think corporate counsel, yeah, they don't really. I certainly didn't feel like I had the opportunity to say, oh yeah, it's one of the 6 countries we do business in Africa. I'll just let them handle it, and they'll let me know how it comes out, right?
Yeah, and nor should you, right?
Right.
And I think that's maybe one of the other things I've noticed over the years is that within a business, the in-house legal function is becoming more important, because it's all about risk mitigation and risk identification, and you have to have a real voice. And the best functioning companies are those where that kind of in-house function is treated as part, has a seat at the table, rather than just a service provider that sort of gets brought in when things go wrong. It's a lot better if people are up front.
So you'd prefer that in-house counsel contact you when the dispute's brewing, not at 5 p.m. when they've just been sued. And to defend myself, you actually knew who I was and what this dispute was about when I said, file.
Yes. I mean, of course, look, everybody's busy, so but all else being equal, it would be better to contact early and try and head something off. I mean, one of the other changes in practice is obviously now, if I'm approached compared to say somebody 30 years ago, we're all alive to the idea of, can we find an early settlement that's acceptable, particularly in a corporate context? Is there alternative dispute resolution or mediation that might work? What are the enforcement options if we're going, there's a whole strategy that perhaps wasn't planned as carefully or in such a sophisticated way, in generations past. And so it is better to get an early heads up wherever possible, even if you end up doing some work and everyone just agrees to sort of let it roll over for a couple of months because circumstances change. Far better than to be on the front foot than sort of have to be reactive.
Well, yeah, and I think that if you trust your outside counsel, there really isn't a too early, right? If I called you and said, hey, I think I have this problem, you're not going to, when there's not an actual problem to solve that day, you're not going to say, great, let me spin up a 15-person team and see if I can bill you $1 million, right?
Exactly. Yeah. And it's not consistent with a long-term relationship, and nor is it, consistent with professional values. So I agree.
I guess do you get most of your clients from people who are already working with someone else in the firm? It must be, it's an interesting business development angle, I would guess.
It is. I mean, sometimes people obviously don't want to talk to disputes lawyers because it implies something may be going wrong, although I conceive myself more as risk mitigation, sort of risk avoidance than purely disputes. Look, I'm in quite a privileged position. I mean, I work at one of the world's leading law firms, and so we have a very strong client list who are used to taking our advice and reaching out for it. Typically, my work comes both ways, both from knowing people and being in the circuit and sort of having from a reputational perspective for myself, but then also from referrals within the firm. And I don't really conceive of myself as having my clients. That we are firm clients. They're firm clients, and we try our best to serve them in a whole range of needs, right? And sometimes disputes are solved through not just the litigation or the arbitration angle, but also through some form of corporate financing transaction. That sort of nature can be a whole, sort of whole range of solutions.
So, on a personal level, you've spent most of your career as an expat. How's that been?
It's been pretty good. I would say, by and large, it's not. There are pros and cons. So obviously the big pros are I'm based in Singapore. That is, the centre. It's becoming a really significant disputes sort of centre and of excellence in Asia. Asia is a culturally, economically, and sort of geopolitically fascinating part of the world, and that opens up all sorts of interesting avenues, both professional and personal. On the downside, of course, my family is split between Australia and the US and other places, and so you lose some in-person contact that you might otherwise have expected to have. But on the whole, I mean, I can't begin the variety of opportunities and things that happen that I deal with on a day-to-day basis. It's fantastic.
So back to money. We've talked a bit about it, but budgeting and cost control. Corporate counsel want budgets, hate surprises, and litigation is famously unpredictable and full of surprises. And an exit arbitration is never inexpensive. So, what's the key then to keeping your client happy with budgeting and cost control?
So, I mean, you're right. It's very difficult, but primarily because, of course, what you have to do is not solely within your control, but turns on what the other side are doing. But the key, I think, comes back to an earlier part of our discussion, which is around communication. So, if you can establish early on what suits a client and what suits the firm in some circumstances. So I have some clients who like to be billed, very regular, relatively small increments. Other clients who don't want to deal with administration would rather just get one larger bill every sort of, in less frequently. But some form of pretty regular communication about what's on the clock, a degree of trust that it'll be reviewed properly and that, appropriate write-offs will be made, etc. That all helps. But there will be, and then a discussion when we know if you've got a scope and the scope's been blown because of something unexpected that's happened, then everybody has to just have an adult discussion about what that means from a pricing perspective.
And I think the level of detail, it certainly surprised me. I mean, I remember we were having, I think it was just a motion hearing um, on an important issue. It was a jurisdictional issue.
Mm.
But if memory serves me right, it lasted like 3 or 4 hours.
Yes,
and being done in multiple languages with those amazing translators that tell you exactly what the person in French is saying as they're saying it. I still don't understand how they do that. But I think if you're corporate counsel, you kind of have to strap in and understand this isn't going to be cheap, and you have to work on your CEO and your board to have them understand that there's not a way to do this like you can't just quickly get it over with.
Yeah, I think that's right. And maybe that's one of the big differences between when you're dealing with corporate counsel who have a litigation background and do not, that some of those, the sort of understanding of just the detail of what will be required and the consequent cost is a little bit easier where people have obviously been through all of those experiences. I mean, part of my job is to educate in that particular regard and also to listen carefully to what comes back. But yes, I think a rule of thumb for litigation is it always costs more than you think it will.
Well, and my experience in setting budgets for litigation, either in-house or outside, is you will always miss it. And I very rarely come in low. I mean, whichever. I've always over. When I did budgets, I would figure out what I thought it was going to cost and multiply by 1.5, and still would miss it sometimes, right?
Yeah, and
you're
obviously
probably better at it than I was.
Well, I mean, arguably, over time, of course, experience helps, and some of the tools that are coming out allow you to probably budget with slightly greater precision, but nevertheless, it's still tricky. Some occasionally, some form of, obviously there are alternative ways to billing them purely hourly rates, and that can provide some certainty. But again, it's quite difficult for large scale litigation.
Yeah. Have you done much in alternative fee arrangements? It seems a particularly difficult area to try and figure out how to do a flat fee or cap deal, because as you said, controlling the other side is impossible. And if the other side decides to, they can make life very expensive.
Yeah. So, I mean, the answer is yes, we have. And of course, we're under pressure as well to try and find different ways to bill that work for clients, and some form of risk sharing occasionally is helpful. One of the challenges with arbitration is that you're often dealing with many different different jurisdictions and different legal traditions, and certain things that would be considered entirely acceptable in one jurisdiction might actually be considered not acceptable at all in another jurisdiction. And so balancing that can be a challenge. Um, Typically, in a litigation, you can find some stages where you have greater certainty over what will happen, and therefore you can be more robust about giving a cap. And then, for example, disclosure early on until you know what the issues are, it can be extremely difficult to know how much that will cost. And whether you're in a US style tradition or Indonesia where there is no disclosure, that has a big impact on budget.
How do you try a case where there's no disclosure?
It tends to be quicker.
It, is it better?
Not always. I mean, there's still an obligation to put forward documents on which you rely. There's just not an ability to request for documents from the other side. So I think that it adds a different complexion to it.
So we've talked mostly about your interactions with in-house counsel, but thinking about transactional lawyers, and I guess we touched on it earlier. Um, have you had deal lawyers approach you and say, "We're putting this deal together. How do I make it work so that I'm protecting my client?" Is that something that's a regular part of your practice?
It is now. It wasn't always. I think one of the things we do internally within our firm is to flag that actually that because we are about risk reduction mitigation in times that there are certain elements of clauses that one can look at. The worst thing what you do not want ever is, say, to have a dispute resolution clause or a jurisdiction clause, and then for it not to work or not to be quite clear, and then you end up arguing about where you're going to argue. That is a complete waste of money and time. So we can help in that way. And obviously, occasionally people run stress tests and say, look, if this was put under the microscope of litigation, how do you think it would be interpreted? Leaving all other issues aside, and that I think helps produce a better product.
How do you feel about in my experience, I've done deals, in civil law jurisdictions where, I think I did a 150 million euro deal on 35 pages of stock purchase agreement or asset purchase agreement, whatever it was. And I've done, much smaller, much bigger, but, American deals are, you know, they're 5 inches high, at a minimum, right?
Yeah.
And pretty
Without
much the same in the
punctuation.
UK.
Yeah.
Exactly. So, what are your thoughts on all the boilerplate in there? Is it drive you crazy, or do you find it to be necessary? Do you run into civil law deals where you wish you had a further explication of what the parties were actually trying to achieve?
So, look, the easy answer is to say I'm entirely agnostic. I'll deal with what comes. But in practical, but the more substantive answer is I think it what I don't like is the unthinking repetition of some boilerplate or recycling of a deal before. That's where things go wrong. If there is thought been given as to what would be appropriate for the deal, then typically you reach an answer, and the answer might be actually something fairly broad and without all of the specificity of every boilerplate clause known to legal kind. But sometimes, of course, it might be different. So there might, if I was thinking about, what's the nature of a deal? If it's a charter party, there has to be some very clear requirements about certain elements of that contract. If they're not there, it's a problem. Or technical specifications for delivery of oil, for example. If it's on spec or off spec, all of that needs to be set out. If the subject matter doesn't lend itself to that degree of precision, then trying to impose it probably causes challenges as well, or more problems than it's worth. So I think it is, to put it colloquially, horses for courses.
What's a charter party?
A lease of a ship.
Okay, got it. Well, and I think you raise an important point about the boilerplate that's there because someone has read it and thought about why it's there is one thing. And most transactional lawyers are starting from a form. I don't know any of them that would sit down and say, okay, right, what should paragraph 1 be? And you have to make sure that at the end of the deal, and making sure is very difficult because deals, they happen quickly or they happen slowly, but they've got their own momentum, and it's very difficult sometimes to say, stop. Now I'm going to sit in a room and read the whole thing until I understand precisely why every clause is there. But at the end of the day, that's the job.
Yeah. I mean, I think it also turns, obviously starting with some form of base is going to be sensible because it will be tested. So to give an example, an ISDA master agreement. So the International Swaps and Derivatives Association, there are trillions of dollars of derivative transactions done every year. It's the most common contract of any kind. And there is an association that sets out sort of standard terms that everybody works from. And those terms have been litigated and sort of proved under the microscope in many different jurisdictions, particularly New York and London. And so it would be madness not to start with those for that kind of transaction. But if you want to have arbitration and not court litigation, you've got to remember to delete the court clause and put in when you put in the arbitration clause, because as I've seen many times, if you have them both, you end up with a pathological clause and arguments about what you've actually agreed. So even that requires some thought.
Having seen that movie, I completely agree. So what would you, if you were, sitting on the shoulder of a transactional lawyer, what's the most important thing that they need to know from you who are going to be litigating that deal 5-10 years from then?
So I think the most important thing is that, at least in the common law system, it will be interpreted objectively, right? So the fact that people said certain things in a room about what they really think it means is not necessarily going to be the complete answer. So actually, one of the boilerplate clauses around pre-contractual representations and their status is important. The other thing I think I would say is just it's always a bit challenging if you get a phone call from a group of people who are in a room saying, we're just about to sign and we just had a question about this element of the clause. That is not helpful. It's far better to have more than the sort of 5 minutes to midnight request.
Got it. So what haven't I asked you that you think that law students, young lawyers, and anyone else happily listening to the podcast would like to know about?
Well, look, I hope there's many listeners, but I think that probably the most important thing I've found in a career that's relatively long and probably got a number of years to go is you've got to be able to have fun. I think it's the practice of law is, whether it's in-house, external, academic, anywhere, is stressful and tiring, and so you have to be able to have fun and take some I think joy out of it, as well as just sort of getting the job done. And that can be personal interactions, it can be a whole different range of things, but keeping a sense of humor and having a sense of fun about it, because it is generally very interesting. But let's face it, every day, I mean, law has its fair share of dull moments and very technical and sort of precise. So you need to be able to see the sort of funny side of that to push through to the better bits.
Yeah, and I think, for particular strange people like us, some of the fun can be in learning how a new industry works.
Yeah.
Definitely.
I mean, that's
I've been
one of
in
the things about being a
I
litigator.
can understand. Yeah, exactly. Go ahead. I'm sorry.
Yeah, sorry, I didn't mean to interrupt. That's one of the benefits of being a litigator is especially in, say, arbitration. I specialize in dispute resolution process, not necessarily in industry. So I can always learn something new about whether it's the telecoms industry or whether it's the energy industry or a variety of different things. And that does add a layer of interest to it.
So if you could go back 20 some years and have a chat with you as you're getting out of Oxford and heading off on the practice of law, what would you like to tell yourself to stop stressing about or to stress about more?
So I'd probably tell myself to stop stressing about things like cross-examination and oral advocacy and all of those things. That comes when you know your brief. That comes with experience and sort of just practice. So I'd be less stressed about that, and less stressed about some of the day-to-day rough and tumble of the practice of litigation. There are always going to be letters which you look at and think, oh, that could have been written better. There are always going to be, those moments where you think, oh, what are we going to do now? Yeah, that's where you earn your money. Really, is coming up with the solution to the tricky problems. And then in terms of things that I'd stress about more, I would have paid more attention, I think, to a lot of what I do is around translating between different cultures or different legal systems coming together, and I would have paid a lot more attention to that, and the kind of subjects that help give you insights than I did before. And the other thing I would have done is learn a second language, because I'm sadly very limited with only English, and actually, if you're going to practice international arbitration, speaking a couple of different languages really helps.
Yeah, I completely agree. I mean, I lived in a French-speaking country for 4 years, and you cannot pick up a second language in your 40s, or at least I couldn't. And I was very heartened to find out that Thomas Jefferson moved to France when he was 42, and he didn't figure out how to speak French either. So if Jefferson couldn't do it, then why would you expect us to?
Fair enough.
All right. Well, Andrew, I think that's all I have. And believe it or not, we are coming up to about an hour. So I really appreciate you appearing. I know it's very late your time, so I really appreciate you making the time. It looks like you're still in the office.
This is my home office, I'm happy to say.
Okay, good. Okay. Thank goodness. Like, I'm keeping you in the office nearing midnight. I'm going to have to send an apology to the family.
No, it's okay. They're asleep outside.
All right.
Thank you very much, Neil. It's been a pleasure.
All right.